In 2005, a group of merchants filed what would become one of the largest antitrust lawsuits in American history. Their target, Visa and Mastercard, the two payment giants that process billions of transactions every year. The allegation was straightforward but explosive. These companies had colluded to fix fees and restrict competition, costing merchants billions. After nearly 2 decades of litigation, a proposed settlement emerged, $5.5 billion. To understand why merchants sued, we need to start with the fees themselves. Every time a customer swipes a credit card, an invisible fee is triggered. According to industry documentation, this is called an interchange fee, a percentage of each transaction, plus sometimes a flat charge, that flows from the merchant's bank to the card-issuing bank. Visa and Mastercard set these rates centrally, publishing schedules that determine exactly how much each type of transaction costs. For a small business processing thousands of transactions monthly, these fees add up quickly. Merchants argued they had no choice but to pay them. According to Federal Reserve data cited in court filings, U.S. merchants paid tens of billions of dollars annually in interchange fees by the mid-2000s. The National Retail Federation, representing merchants, described these fees as a hidden tax on commerce. Unlike negotiable contracts, interchange rates were set unilaterally by Visa and Mastercard. Merchants could accept cards and pay the fees, or refuse cards and risk losing customers. This dynamic, plaintiffs argued, was not a free market, it was a controlled system. In 2005, a coalition of merchants filed suit in the U.S. District Court for the Eastern District of New York. The complaint, which would be consolidated with other claims, alleged that Visa and Mastercard violated federal antitrust law. Specifically, the merchants claimed the companies conspired to fix interchange fees at artificially high levels and imposed anti-competitive network rules that prevented merchants from steering customers to cheaper payment methods. The case was designated in repayment card interchange fee and merchant discount antitrust litigation. According to the complaint, Visa and Mastercard together controlled over 80% of the U.S. credit card market. The merchants alleged this duopoly allowed the companies to set interchange fees without competitive pressure. Furthermore, network rules prohibited merchants from offering discounts for cash or cheaper card brands. Court documents show plaintiffs argued these rules were designed to insulate Visa and Mastercard from price competition, locking merchants into a system where fees could only rise, never fall through market forces. Visa and Mastercard denied the allegations. According to statements filed in court, both companies argued that interchange fees serve legitimate business purposes, compensating issuing banks for fraud risk, processing costs, and the value of guaranteed payment. They maintained that their networks compete vigorously and that merchants benefit from increased sales volume when they accept cards. The companies also noted that interchange rates varied by card type and merchant category, reflecting market conditions rather than collusion. The case dragged on for years. According to court records, discovery produced millions of pages of documents. Depositions were taken from executives at Visa, Mastercard, and issuing banks. Expert witnesses testified about market structure, pricing behavior, and economic harm. By 2012, the parties were discussing settlement. The complexity of the payment card industry, spanning issuing banks, acquiring banks, processors, and networks, meant proving antitrust harm required enormous resources. Merchants and card networks both faced uncertainty if the case went to trial. In 2012, Visa and Mastercard proposed a settlement initially valued at $7.25 billion, which would have been the largest antitrust settlement ever at the time. According to court filings, the deal included cash payments to merchants and modest reforms to network rules. But many merchants objected. Trade associations representing large retailers, including the National Association of Convenience Stores and the National Retail Federation, argued the settlement provided insufficient relief and released too many future claims. In 2016, Judge Margot Brody rejected the settlement, citing inadequacy. With the settlement rejected, litigation resumed. Appeals followed. According to the Second Circuit Court of Appeals docket, various merchant groups pursued separate claims, some focusing on damages, others on injunctive relief to change network rules. the case fractured into multiple tracks. Meanwhile, Visa and Mastercard continued to operate their networks, and interchange fees remained in place. The legal battle had become a war of attrition, with both sides investing millions in ongoing litigation costs. In December 2023, according to court documents, Visa and Mastercard reached a new proposed settlement with the class plaintiffs. This time, the deal was valued at approximately $5.5 billion in cash, paid over time to eligible merchants who accepted Visa or Mastercard credit or debit cards during the class period. The settlement also included provisions allowing merchants, for a limited time, to surcharge credit card transactions to offset the cost of interchange fees, a practice previously restricted by network rules. According to the settlement terms, the $5.5 billion fund would be distributed among class members, millions of merchants spanning convenience stores, restaurants, retail chains, and online sellers. The exact payout per merchant would depend on the volume of card transactions during the relevant period. Additionally, the rule changes could allow merchants to steer customers toward lower-cost payment options, potentially saving money on future transactions. However, these concessions would be temporary, expiring after a set number of years according to the agreement. Not all merchants supported the deal. According to filings reported by Reuters and Law 360, major retail trade groups again raised objections, arguing the settlement did not go far enough to reform the interchange system. The National Association of Convenience Stores and the National Grocers Association both publicly opposed the agreement, stating it would lock in fees for years to come while providing only modest temporary relief. They urged the court to reject the settlement and allow the case to proceed to trial for more meaningful reforms. Settlement approval rests with U.S. District Judge Margot Brody, the same judge who rejected the earlier proposal. According to legal analysts quoted in Law 360, she will evaluate whether the settlement is fair, reasonable, and adequate under federal class action rules. The court must consider the strength of the plaintiff's case, the complexity and expense of continued litigation, and whether the settlement provides meaningful relief. A fairness hearing was scheduled, during which objectors could present their arguments and class members could be heard. According to industry observers cited in the Wall Street Journal, this case represents the culmination of decades of tension between merchants and card networks over interchange. Even if approved, the settlement would not fundamentally restructure how Visa and Mastercard set fees. Interchange would continue to be determined by the networks, not by competitive bidding among merchants and banks. Some economists argue that only regulatory intervention, such as caps imposed by Congress or the Federal Reserve, could achieve lasting change. The settlement, they note, is a compromise, not a transformation. Both Visa and Mastercard have stated publicly that the settlement allows them to resolve long-standing litigation without admitting wrongdoing. According to a Visa press release, the company believes the agreement balances the interests of all stakeholders and enables the payments ecosystem to move forward. Mastercard echoed similar sentiments in its own statement, emphasizing its commitment to innovation and secure payments. Neither company has announced plans to alter its interchange fee structure independently of the settlement. The networks continue to dominate the U.S. market. As of early 2024, according to court filings, the settlement remains pending final approval. Judge Brody will hold hearings, review objections, and decide whether to give the deal her blessing. If approved, claims administrators will begin the process of distributing the $5.5 billion fund to class members, a task that could take years given the millions of merchants involved. If rejected, the case could return to trial, or the parties might negotiate yet another settlement. For merchants, the wait continues. The Visa and Mastercard merchant lawsuit is more than a legal dispute, it is a referendum on how payment networks function in America. According to economists who testified as experts, interchange fees are embedded in the cost structure of nearly every retail transaction. Consumers rarely see them, but merchants pay them on every swipe. The $5.5 billion settlement, whether approved or not, underscores a fundamental tension between the convenience of card payments and the cost of participating in a system controlled by two dominant networks. That tension is unlikely to disappear, even if this case is finally resolved.